Well, good evening, everyone, and welcome back to AJ103, Criminal Evidence Online. And tonight's lecture is going to cover Chapter 11, Developing Law of Search and Seizure. Now, we've got a lot of information to cover, and I know I've said that a few times during some of these lectures, but there is so much there and so much content when you're talking about search and seizure. So again, I'm going to touch on the key terms and some of the key elements, and I'm going to have you go back and fill in some of the blanks to add context to the lecture as we go through this particular chapter this evening. So we're going to start with this scale that measures how much information and what kind of information as it relates to like what you need to search. So you look at 0 is no information, and to the right is like 100% certainty. And with that, I want you to take a look and kind of figure out where do they come in, and kind of put a number. Is it at 10%? Is the hunch and suspicion is say 25, or reasonable grounds, or probable cause, or preponderance of evidence? How would you fill this in if you had the ability to do that? So take the time to do that, and I think you'll have a better understanding of what we're talking about. Now, here's kind of a good way to look at it. When you're talking about a scale that measures how much information and what kind of information, well, to give you an example, and I didn't fill in the bottom part for you, this thing, preponderance of evidence is about 50% plus 1, just a little bit over. And beyond a reasonable doubt, which you're going to find out what we need in a few minutes, that's what you need to search and arrest somebody, that's like 95%. So I'll let you again kind of think as we go through this lecture and where those numbers would actually kind of play out. So here's our case for this evening. So in 2012, Lois Goodman's husband, Alan, was found dead. And police soon suspected Miss Goodman. Now, the police obtained 7 different search warrants during this investigation and performed an autopsy, then charged Mrs. Goodman with homicide. Now, the case was later dismissed, but it might be reinstated. So take a look at this case of Lois Goodman. And it appears on its face that she's this super upstanding citizen that was a tennis official and ended up getting caught into this whole realm of possible homicide, etc. But I'm going to let you kind of decide and read the case. And then we'll come back later and we'll talk a little bit about it. So, but when we apply the law, so after you read that, think about these questions, or read the questions and then think about it as you read the case. The police had months to investigate and use 7 different search warrants. And at some point, do the warrants become weapons to just harass or intimidate somebody? And did it matter here that Mrs. Goodman was rich? Does it matter? And should there be limits on the police? And yes, there actually are. So read the case, think of those questions, and let's talk about the learning objectives. So quickly, we want to be able to define what is a search and a seizure and probable cause. What do those mean? And we want to have a basic understanding on how search warrants are written and granted and executed. And then we want to explain what they call the exclusionary rule and this weird phrase called fruit of the poisonous tree. And then we want to be able to also understand the exceptions to the exclusionary rule, because yes, now it's not like hearsay. oh my gosh, where there's so many exceptions, but there are exceptions to the exclusionary rule. So here's some facts and myths, well, about warrants. So myth, if the police wish to conduct a search, they have to obtain a search warrant. Well, yeah, kind of, but there are exceptions to the search warrant requirement. Can you think of one? I'll let you think about that. Well, how about the safety of an individual inside of a house? Maybe there's a fire going on or somebody's screaming in a house or something. So would that allow officers to at least make entry to make sure somebody was okay? Well, another one, for a judge to issue a valid search warrant, there must be sworn testimony from at least one eyewitness. Well, not really. But the U.S. Supreme Court allows judges to issue search warrants based on the totality of circumstances. And you'll see something called the Fourth Amendment in a few minutes, to where you have to have this cool word called probable cause. How about when serving a search warrant, the police may seize things that are only named in the warrant? Well, yeah, kind of. The police do have the right to seize anything that falls under another exception called the plain view doctrine. So here you go. And let's kind of jump into tonight's lecture. The English Bill of Rights was enacted by Parliament in 1689 and gave even the poorest peasant the right to exclude the king from his home. Now, yet in colonial America, the British freely used the quote, general warrant, if you will, which gave them unlimited rights for soldiers to search homes for whatever they want to find. Now, many of the original states expressed their disapproval of this general search warrant concept by including a prohibition against unreasonable searches and seizures in their constitutions. And when the U.S. Constitution was ratified, it did not contain any mention of searches and seizures or any of the other protections now found in the Bill of Rights. Now, many of the states that ratified the Constitution insisted that additional protections against the power of the federal government be included. And therefore, the first 10 amendments to the Constitution were added in 1791. And only 4 years after the Constitution was ratified, their wording has not been changed since. So what is the Fourth Amendment? Well, the right of the people to be secure in their persons and houses and papers and effects against unreasonable searches and seizures. It doesn't say against all seizures, etc. It says unreasonable. Shall not be violated, and no warrants, okay, shall be issued but upon this word called probable cause, and we'll figure that out, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. Now, you're going to notice some similarities to a couple things in here. Now, when we talk, and while this chapter talks a lot about search warrants, and this isn't really an entire search and seizure class, when an officer searches someone in the field or arrests them, the standard by which to do that is probable cause. You have to have probable cause to search and to arrest. So you saw here, well, what about a warrant? What about when we want to come to your house? Well, they're saying it's basically the same thing. So no warrants shall issue but upon probable cause. And oh yeah, so in a regular case where somebody might arrest somebody and search them and arrest them, etc., and they go to court, the person testifying has to swear by oath or affirmation. Well, here, for a search warrant, you still have to do that. And it's done through an affidavit, but we'll talk more about that. But these are some similarities between, searches without warrants and warrants. But that was the Fourth Amendment. So again, before the American Revolution, the British, they searched home and businesses wherever and whenever they wanted because they had this general warrant requirement that said that, it gave unlimited rights for soldiers to kind of search houses for whatever they might find, so they could go on a fishing expedition. Now, the Fourth Amendment bars these warrantless searches and seizures. Okay, and there are some broad concepts, if you will. So there are three broad concepts in this amendment. And the first is protection is provided for the person, the home, and their belongings. And the second thing is against unreasonable searches and seizures. So these are prohibited. Not all searches or seizures, just those that are unreasonable. And that warrants must be based on this thing, probable cause, and describing what is to be searched for and what is to be seized. As opposed to what we just looked at a minute ago, where these general warrants, you could just go in and search for whatever you wanted. So you've seen the evolution of search warrants, if you will, and a little bit of the history, the evolution of the Fourth Amendment. And some more of these concepts will be explained later, I think in chapters 12, 13, and 14. But let's look at some definitions now, because I think we're going to have to know some of these. If you want to know a little bit more about the Fourth Amendment before we jump into it, there's a cool link to a YouTube video that talks about the Fourth Amendment. And I think it would be nice for you to watch it. The guy that does it's pretty cool, and I think he will kind of give you a little bit more, good information. But we already know, here's the verbiage in the Fourth Amendment, and here's what it forbids. And then we're going to get into this later. This thing called the exclusionary rule, which is based on a couple of major precedent case laws. And one is Weeks versus United States, and the other is Mapp versus Ohio. And again, where it requires probable cause, etc. So that's a little bit more on the Fourth Amendment. And the exclusionary itself, the exclusionary rule, is based on this case law, Mapp versus Ohio. And I have a link to two different videos for you to look at. Now, the one on the bottom here, this Annenberg Classroom, this is a really good video, folks, on Mapp versus Ohio. So I would suggest that you utilize these resources to watch this stuff to help you add context. Now, back to what we were talking about. So some definitions. Well, what's a search? And we have to kind of know these. So before considering what police conduct violates the Fourth Amendment, we should probably know some basic definitions that are going to be discussed, like search and seizure and probable cause and this thing called standing. So what are those? Well, a search is an examination of a person, his or her house, personal property, or other locations conducted by law enforcement officers for the purpose of finding evidence to a crime. And, not every act of investigation is a search. And not every search is covered under the Fourth Amendment either. And only unreasonable searches impact admission of evidence. Okay, so good searches, obviously, they don't. Only those that are deemed to be unreasonable. Well, what about an example of a search? So just to kind of help us out, let's look at a quick example. Well, a police officer orders the suspect to empty his pockets and examines each item that is produced. Now, if the officer did this before arresting the person, the search would actually be unreasonable. But if the officer arrested the person before ordering the pockets emptied, the officer's actions, they would be reasonable, because after you arrest somebody, the law says that you can then search them. And they call this like search incident to a lawful arrest. And again, a lot of terms, a lot of stuff for us to go to. Well, how about an example that's not a search? Well, a police officer was walking through the park and observed a young man smoking a cigarette. And the air was full of the smell of marijuana smoke. Now, I know this might change a little bit with the fact that marijuana is now legal, but still you have the right under certain circumstances to investigate certain things. So, in this particular case, the park is a public place, therefore, what the officer observed while walking through wasn't a search. Now, picking up the person's backpack and looking in it, that would be a search. Now, if the officer arrested the person, could he or she then legally search the backpack? And the answer would be yes. Search incident to a lawful arrest. So what's a seizure? Okay, this isn't in the medical sense. So a seizure is the act of taking possession of a person or property. Now remember, it can be a person, okay? Taking possession of a person or property. The seizure of a person is an arrest by definition. But seizure of an item requires the owner to have an expectation of privacy and control. So police seize evidence when they take it in their possession. Even when there is no search, like something in plain view, the officers still have to have probable cause that it's contraband, etc., in order to seize it. So again, that's like search and seizure. So we've kind of talked a little bit about that, but let me give you a little bit more on a search. A search involves the act of looking for something that otherwise would not be seen. It does invade someone's reasonable expectation of privacy. And finding something that was left out where the police could see it is not a search. So if it's just left out there, does that kind of make sense? So even if there is a search, it may not violate the Fourth Amendment. Remember, it has to be unreasonable, and there's more on searches on page 316. And we just kind of went through what a seizure is. Police seize evidence when they take it into their possession. And when a person is seized, it's called an arrest. And even when there's no search, like something's left out in plain view where an officer can see it, the officer still has to have probable cause to seize it, to take it. Does that kind of help everybody? So an example of a seizure: police stop a man carrying an object that appears to be a gun, and they take it. Okay, that one's pretty simple. Well, here's an example of something that's not a seizure. It's pretty close, but it's not. Police stop a man walking down the street at, let's say, 11:30 p.m. in an industrial area. They ask for identification and the reason that the man is at the location. And the man explains, and the officers allow him to go on his way. Now, again, that was kind of close to a seizure, but there was no taking into custody, there was merely a little bit of, a very short detention at best. And therefore, this would be an example of something that really wouldn't be a seizure. So hopefully that kind of helps. Now, other examples would be if a police officer observes something inside a house by looking through the window, and there's no right to enter the house to seize it without a warrant. Another example would be information that is discovered while in a police helicopter patrolling the area. Observing the backyards and fields in this manner is not a search, because the officers in the helicopter are looking at items that are in plain view. And what about abandoned property? Well, abandoned property kind of goes by a different rule, because no one currently owns it or has kind of possessory interest in it. And again, evidence that's left in a public place can be seized without a search warrant, because there's no invasion of privacy of anyone's property interests. And there's some examples on things that are seizures and things that are not seizures on page 318. So I'm hoping these things kind of help. So now we're going to talk about the big thing, probable cause. Now, the Fourth Amendment specifically refers to issuing warrants based on probable cause. And probable cause is also an important prerequisite for many police activities conducted without a warrant. So remember, in order to make an arrest. So let's go through those. So in criminal cases, probable cause is required in 3 key situations. So the first would be probable cause that a crime was committed. And the next would be that probable cause that the suspect is the person who committed the crime. And the last one would be probable cause that evidence is at a specific location. So now we know the definition of probable cause and the 3 key situations or elements, if you will, that are required for these key situations. Now, a little more on probable cause. Reasonable belief, kind of a definition, if you will, based on facts that a person committed a crime or that a location contains evidence related to a crime. So when we're talking, again, about a kind of definition. So reasonable belief based on facts that a person committed a crime, that would be enough for you to arrest, or that the location contains evidence related to a search or a crime, and that would be the search or a search warrant. And it is necessary before an arrest or a search warrant is issued. And probable cause may also be used to conduct some arrest and searches without warrants. So while we've kind of focused a little bit on warrants, we need to know that this probable cause standard typically is used to conduct some arrests and searches without warrants as well, because an arrest in the field typically is not done with a warrant. It's based on a crime that you've investigated and may have occurred in your presence and different things like that. So we have to kind of keep that broad definition. So what are some examples of probable cause where there might not be a warrant? So let's try this one. Police arrive at the scene and observe the suspect hitting another person with a bat. Now, do you have probable cause to believe that a crime has been committed in your presence? And if you do, then you have enough to arrest and search an individual. Well, how about this one? A woman calls 911. And when the police arrive at her house, they see that the woman has marks on her face indicating that she's recently been hit. And the woman tells the officers she was hit by her husband. Based on what she said, do you possibly have probable cause to make an arrest on the husband? Now, if nothing else, you do have reasonable suspicion to believe that the husband was involved in this incident based on her statement and the marks, and you certainly have enough to detain and interview him. And from there, you might have enough at that point, probable cause, or you might need a little bit more information. But once you develop probable cause, you can, in fact, make the arrest. And I would kind of stipulate that if you found the person and you were able to see that maybe he had some blood on him or something else, that you would probably have probable cause to make an arrest at that particular time. And then the last part. Now remember, this is number 4 out of 4 things that we were talking about relating to definitions. So we know what a search is, and now we know what a seizure is, and we just talked about probable cause, and now we're going to talk about this thing called standing. Now, standing is a legal term that refers to the right to ask the court to take legal action. And only a person with standing can ask the judge to rule that evidence can't be used at trial because it was illegally seized. Now, after many years of struggling with this concept, the U.S. Supreme Court adopted this reasonable expectation of privacy standard as a guide and really no longer uses the term standing when deciding if evidence should be excluded because it was obtained in violation of the suspect's constitutional rights. And a person can ask to have evidence excluded due to a violation of the Fourth Amendment only if it can be shown that their privacy was violated by the police. Does that make sense? So I don't have standing over a search relating to you. So, and we'll talk a little bit more about that. So, to object to a search, it must be the party on trial, their rights that were violated, not somebody else. Now some examples illustrate this approach. So, if a person's house is searched unconstitutionally, the resident's reasonable expectation of privacy, has been violated, and the person who lives in the house can have the evidence suppressed if charges were filed against him or her. Now, an overnight guest who was present when the house was searched also has an expectation of privacy that was violated when his or her belongings were searched. And the overnight guest can have the illegally seized evidence suppressed. On the other hand, if a friend left something in the house but was not present when the illegal search was conducted, the friend has no reasonable expectation of privacy. And this conclusion is based on the rationale that by giving up possession of the property, the owner gives up control of the item and therefore has no expectation of privacy. And without an expectation of privacy, the friend can't have the court suppress the items that were seized by police. And this is true even though the police seized the items during a search that was illegal. So the Supreme Court has also ruled that people who stop briefly at a home or apartment for business purposes, they have no expectation of privacy in the residence that they're visiting. And these visitors cannot have property suppressed that the police seized illegally. And there are some other examples on page 320. So hopefully we've been able to explain this thing standing. Well, here we go. Here's kind of an example. Standing. At a party, Pete gave Rosie a small bag containing illegal drugs and asked her to hold them and put them in her purse. And, she was dumb enough and she did. And the police raided the party. And you know what? They found the drugs. Now, the judge would not consider Pete's request to have the drugs suppressed at his trial because why? Well, because they weren't in his possession. When he gave Rosie the drugs, he gave up the right to challenge any search. Does that kind of help as well? So hopefully it does. So now we're going to kind of like go back and we're going to hit like warrants again, and we're going to talk about some requirements. So we've gone through those 4 things. We've talked about standing and probable cause and seizures and searches. Well, now let's talk a little bit about warrant requirements. So the 4th Amendment, we've read that a few times now, specifically states, 1, no warrant shall be issued unless there's probable cause. 2, probable cause must be established under what? Oath or affirmation, right? Someone's going to have to provide supporting information. Oh, and by the way, they're going to have to like swear by it. And 3, the warrant must particularly describe the place to be searched and the person or things to be seized. So describe the individual if it's an arrest warrant, or the item and place if it's a search warrant. And the 4th Amendment does not say, again, that all searches must be authorized by warrants. Now, the Supreme Court has decided many cases addressing the issue of whether or not warrants are required, and it has stated a preference for warrants, but has also recognized that there are many situations in which officers do not have to get them. Now, search warrants may be issued to search nearly any location, including residences, newsrooms, lawyers' offices, etc. And one other thing that is kind of thrown in there when you talk about search warrants is that the reason, well, they want them to be made, reviewed by a neutral magistrate, somebody that's not directly involved in the case. And another thing, the reason that the Supreme Court has said that, you know what, we have a preference, everybody, that we would like search warrants to be issued or arrest warrants, but you know what, there are times when you don't have to have them. And the reason they say that is because this allows somebody with an additional look, if you will, to make sure that someone had probable cause in order to make an arrest or make a search. So search warrants are always preferable, and they include another party, and a neutral magistrate that's going to look, because officers, when they're out in the field, they don't have any other neutral party that's going to look and review their stuff before they make the arrest. Does that kind of make sense? So that's the preference over search and arrest warrants. But there are lots of times, again, I don't want to get confused or confuse you here, where law enforcement officers can make an arrest without a warrant, and they do it all the time. As a matter of fact, most arrests are in fact made without warrants. So let's look at the parts, I guess, of a search warrant. And there are different parts to it. So if you go back kind of up here, the requirements of a warrant, well, probable cause, an oath or affirmation with supporting info, describe the individual if it's an arrest, or the place if it's a search. And then we have the neutral magistrate. So let's talk about this thing called an affidavit, and what does it really kind of mean? Well, the warrant process mandates that a neutral magistrate, like I said a minute ago, reviews the facts and decides if the police should be authorized to conduct a search or make an arrest. Now, to do this, the magistrate must see the facts of the case or have the facts of the case. And the Fourth Amendment requires that these facts be taken under oath or affirmation. Now, the written document used for this purpose is called an affidavit. And these are facts given in an affidavit, are usually very detailed. And again, they must convince the judge that there is evidence at a specific location that the officers have a legal right to go get or to seize. And the warrant may also authorize a search for illegal drugs or other kinds of contraband, or fruits of the crime, like scales or something like that, or P&O sheets for narcotics, and even items used to commit the crime. And the facts in this affidavit, they need to be detailed about the crime and why the officers want to seize it. So, in addition to showing what is to be seized, the affidavit must show the facts or give facts that show where the items are going to be. So not just what they're going to get, but where these items are going to be, or where they're located at. And having this information in the affidavit is merely not sufficient. The items to be seized must also be listed in the warrant. The description of the location to be searched must be as exact as possible. And since the reason for requiring search warrants is to be, it's to protect people's privacy, so the warrant should be worded so that the police are restricted to the smallest area possible. And I'll tell you kind of how that goes about in just a second. So again, the affidavit must also show or give facts on where these items are at. And that affidavit generally limits the search. And the courts say, hey, you know what? The search should not exceed the contents of the warrant. And warrants that are done without sufficient probable cause are basically invalid. And if I have time at the end of this, if I haven't included what a warrant looks like, maybe I'll have time to pull one up and we can take a peek at it. So another unique requirement of a search warrant would be what they call when a warrant is fresh or stale. So a problem unique to search warrants is the requirement that the information be fresh, like up to date. And if the facts are stale, they may not be as reliable or be a reliable indicator of where the items to be seized are currently located. So maybe they were there before, but maybe they're not there now, if that makes any sense. So you basically have 10 days to serve a search warrant. And if you don't serve it within that time, you have to go back and basically refresh your search warrant again and maybe add some additional information. You can keep a lot of it the same, but you'll add some additional information to freshen up your warrant to make it more up to date. And then the judge will review it and then re-sign it again. And then you'll have an additional 10 days because they don't want you just going around on a fishing expedition. They have that 10-day time period, thinking that if it's beyond the scope of that 10 days, then it's kind of stale, and maybe what you're looking for might not be there anymore. So hopefully that kind of explains what that means. So let me go ahead for a second. Okay. So let's look at this case, United States versus Leon. Now, police got a warrant to search the homes of 2 drug dealers. And on its face, the warrant was valid, but later it was found to lack probable cause. Now, the evidence found, however, was still admitted because when the police executed the warrant, they did so in good faith. Basically, they believed that it was a valid warrant. So there are a couple of circumstances that happen or that take place, and one is the good faith rule, if you will, where if officers believed that the warrant was valid and they served it in good faith, then there's a possibility that the information will still be allowed and valid. So now, before we get to our next part, which is going to be talking about arrest warrants, let's finish up with one thing on search warrants. Now, if you're looking at your book, on page 323, there's a diagram that shows the execution of a search warrant. And in this photograph, it shows like a large, like a door and some Coke bottles and a big barrel and a box and a little bag and a big file cabinet and a washer and a dryer and a laundry basket and some other boxes. And let's say in this particular instance, the search warrant stated that officers may search this garage for an assault rifle and a 55-gallon drum of methamphetamine pills. So if you were to look at this picture, and hopefully you can see it in your book, and I may have it further in this lecture, and we talked about, remember, limiting the scope of the search. Sometimes this scope is judged valid or not based on what you're looking for. So if we're looking for, let's say, an assault rifle, could you hide that in a very small lunch bag? Now the answer would be no, so that might limit your ability to look in the lunch bag. Can you hide it in a laundry basket? Probably not. But could you hide it in a big 6-foot stand-up refrigerator or file cabinet? Well, yes, you could. So that would be obvious that you would be able to or allowable to search that. Does that kind of make sense? So it would be like if you're serving a search warrant for big screen 50-inch TVs, you can't be going through somebody's drawers to find a 50-inch big screen TV. Unless the warrant specifies, or you're looking for something different, like maybe narcotics that are like very, very small. Does that make sense and add context to that? So I hope it does. So some questions. Should an improper action by one police officer be attributed to everybody? And what if a police officer files false evidence to get a warrant, but the officers in good faith, they execute the warrant? Think about that one. And should the police have a presumption they did or didn't act in good faith? Well, they're all kind of good questions. So now that we've talked a little bit about search warrants, let's look at arrest warrants. So for an arrest warrant, facts must be given to establish every element of each crime listed in the warrant. And additional information must be included to show how the person named is the one who actually committed the crime. And the physical description of the person is, to be arrested, along with his or her date of birth, if you have it, or approximate age is good, is usually required so the officers making the arrest can verify that they have the right person if they stop them. And it is possible to obtain an arrest warrant even if the name of the suspect is not known. If a detailed description, usually including an alias or a street name, is given, so like a nickname or something. So arrest warrant, the contents, facts supporting every element of the crime, the physical description, DOB, name or alias. And the process is kind of the same, where you prepare the affidavit with probable cause, right, because you're going to make an arrest, for each element. And the affidavit is signed under penalty of perjury. And it's given to the judge just like a search warrant for review. And then after they sign it, you go out and you execute the warrant. Well, what about that just, where you don't have a name again? That's kind of weird. So can we get an arrest warrant based on a DNA match? Or can we get an arrest warrant based on just like a fingerprint match? Interesting thoughts. Well, the answer is yeah. So, and for like DNA warrants, they call them John Doe warrants, but let me go through some of this. So in some sexual assault cases, it is possible to successfully run a DNA test, but not match the results to a known suspect. Now, an arrest warrant can be obtained based on the DNA report rather than the name. So as I talked about before, if we don't have somebody's name, we might be able to get an arrest warrant, on their alias or their street name. And here, though, we can get an arrest warrant on the DNA report or profile rather than a name. Now, the statute of limitations is satisfied based on the date the warrant was issued, and the prosecution can proceed once the person is actually caught and identified by name. So, and they call these, the kind of slang name for them, if you will, would be like John Doe warrants, meaning like, we really don't know who it is, so we're just going to kind of go with John Doe, that name that everybody sort of, calls, let's say, victims that are found or dead bodies that are not identified. They're given the name of John Doe until they are identified. So, what about this? Staying with arrest warrants, let's talk briefly about the reliability of facts in an affidavit. And we've talked about search warrants at length, so let's look more in the arrest warrant section. So due to the fact that an affidavit is usually reviewed by a judge without a chance to question the person providing the information, like the informant or a witness, the affidavit must also convince the judge that the facts are reliable. And if the officer making the affidavit observes the facts firsthand, the fact that the affidavit is made under oath is sufficient to establish that reliability. So if I saw it as an officer and I put that in my affidavit, that's enough. Now, information provided by crime victims and eyewitnesses is usually assumed to be reliable unless there's some motive to falsify. And one problem that frequently occurs is that victims do not provide enough details to identify the suspect. So sometimes there's a need to provide, a higher level of details, if you will. Now, informants who are themselves criminals, they kind of create the biggest problem. And why do you think that might be? Well, maybe because they're criminals. And due to their past convictions or a bad motive for incriminating someone else, they do lack credibility. Now, in a case called Spinelli versus United States, the Supreme Court established a rule that required applications for warrants to establish probable cause for the action sought, like search or arrest, and separate probable cause that the informant is credible. And that's called the Spinelli standard. Now, some states still follow this rule, but most have adopted a more lenient standard. And this is in a case called Illinois versus Gates. Now, when a warrant is sought in a state that follows the Spinelli standard, facts stated in the affidavit must establish the reliability of the informant. And the most common method used to do this is to give specific examples of the useful information that the informant has given to you in the past as an officer. And if in previous cases officers checked out the facts supplied by the informant and found that they were good, the informant's reliability in that current case is basically enhanced. And another method to verify the information provided in the present case. Now, when reliability is established by verifying facts, the Supreme Court insisted in Spinelli that the facts that were checked showed, criminal activity. So merely verifying innocent facts such as addresses and telephone numbers isn't enough. But what about Illinois versus Gates? Well, in 1983, in Illinois versus Gates, the Supreme Court ruled that anonymous tips could also be used to obtain search warrants. And the court ruled that the reliability of an informant can be established by showing that the facts are so detailed that only a person with first-hand information could actually know them or provide them. Does that kind of make sense? And when an anonymous informant is used, it is especially important that as many facts as possible be given in the affidavit. Now, even so, the police must verify as much of the information as possible prior to seeking the warrant. And a distinction can be made between confidential informants and anonymous ones. And so confidential informants give police information on the condition that their names will not be revealed. And the police know who provided the information and can determine his or her credibility. Now, people whose identities are unknown are referred to as anonymous informants and frequently provide information to the police. Now, they may call a hotline or WeTip and leave a message on someone's answering machine, or they may talk directly to an officer without identifying themselves. They'll give you the info, but they don't want to give us the name. And it would be impossible for the police to verify the credibility of these individuals or give their names to the defense as well. So here's the Illinois versus Gates case. And the Supreme Court here heard an appeal from a case where police got an anonymous letter claiming that the Gates were drug dealers. And under the old Spinelli standard, remember we talked about that, the search made by the police probably lacked sufficient cause. But the Supreme Court in this case overturned Spinelli, creating a totality of the circumstances test to judge if probable cause existed for a search. So now we typically use this Gates versus Illinois. So again, for an arrest warrant, the newer standard, use the totality of the circumstances to judge the information in affidavits, particularly as they relate to informants. And then we just covered the fact that confidential informants, they give information on the conditions their names won't be revealed, and the people, they can be paid or working off a case, and we do have paid informants. And then the anonymous ones are the ones that really don't give their name or leave their name, like on WeTip, or they do talk to you, but they just don't want to give their name. They want to remain anonymous. So now that we know a lot of the different parts of a search warrant, if you will, what's the procedure in getting them? How do we go do this? Well, the Fourth Amendment merely requires that a warrant be issued by a neutral magistrate. And in most policing agencies, however, the case is reviewed by the officer's supervisor prior to seeking a warrant. And additionally, sometimes the prosecutor frequently reviews the file to determine if a warrant should be sought, etc. And sometimes the prosecutor prepares the proper forms and helps the police draft the warrant and the affidavit, if you will. Now, the completed warrant application is presented to a judge or a magistrate who must be neutral and really shouldn't be part of any of the law enforcement agency itself. So, again, the procedure is, obtained from a neutral magistrate, of course, acting inside their jurisdiction. And felony warrants may be restricted to certain courts, and typically the warrant to be executed, during daylight hours, if you will. And police, they are required to identify themselves. And we'll get into some of that a little bit more. But if you look on page 330, there's going to be the process to obtain a search warrant. And we're not going to have time to read down that whole thing. But again, so it's the draft affidavit, with probable cause. And then, it's going to go all the way through presenting the affidavits to the judge and having the judge review it and executing the search warrants. And then when they execute it, there has to be, knock and notice. And it talks about you have to execute it before the warrant expires. And look at page 330. You'll be able to find that whole process as you kind of go down the line. So here's a little bit more. Now, once a request for a warrant has been rejected by a judge, it may not be taken to another judge in hopes of obtaining more favorable decisions. However, new affidavits containing more facts can be drafted, and the process can kind of start again. And this might require a little bit more work for the police in order to develop additional information, or it might merely mean that a careful review of the file showed some original information left out. Some key facts were left out of the first draft of the affidavit. And the same is true if it becomes obvious to the police that the warrant they obtained doesn't authorize a search of all areas believed to contain evidence. Now, many states also require that search warrants be executed in the daytime, typically 6 a.m. to 10 p.m. And I know 10 p.m. might seem like dark time for some of you, but this is typically what they call daytime. But if facts exist in the warrant application to support a request that the warrant be executed later at night, the judge can actually designate it for night service. So when we talk about execution, and we're kind of going a little bit further into the warrant process, a warrant directs a peace officer to take specific action like search or arrest. And the act of doing this is called execution of a search warrant. So the act of arrest or search under authority of a warrant, that's execution. And again, it might be necessary. A police officer may take civilians along when executing a search warrant. For example, The warrant authorizes a search for jewelry stolen during a residential burglary, and the owner of the jewelry store may go with the law enforcement officers to help identify stuff. Now, typically, we don't do a lot of that. Typically, we'll search for the items. If we believe we found them, we have probable cause to seize them, we'll take them to the station and we'll have the person come identify them there. But these are things that can be done. But more importantly, on the execution side, the officer executing the warrant is responsible for verifying that the warrant is valid on its face, which means the warrant looks like it was legally issued and has not expired, hasn't passed that 10-day deadline. And the officer is not liable in a subsequent civil case if a judge issued a warrant without probable cause, unless the officer knew there was a problem with the warrant. Okay, so those are some situations there. And of course, officers are expected to respect people's privacy, but are allowed to take reasonable precautions to protect themselves. And this results in 5 different requirements. So let's look at some requirements for execution. Now, generally, we require warrants again to enter homes. But sometimes there are some exceptions under emergencies and hot pursuit. So absent an emergency or consent, a warrant is going to be required. Now, prior to entering a home, the officers must comply with what's called knock and notice or knock and announce. And this is where they identify themselves as a police officer and they announce their cause. And they wait a little bit for entrance, and it's called reasonable time. Then there's really not a time frame. And I'll get into knock and announce a little bit more in depth if we have time. But this has to be done. And you might hear or watch a video where they pound on the door and you'll hear, police department search warrant, demand entry. So they're knocking and announcing. They're identifying themselves. Police officer. They're announcing the cause. Search warrant, demand entry. And then they're waiting for a small amount of time, and then they're either someone's going to open the door or they're going to force their way in. And there are also occasions where no knock warrants are allowed, meaning that they don't have to do the knock and notice. And this is typically when there's a danger to police or victim or the public. If you know the person is manufacturing machine guns in the house, you don't want to knock on the door and announce yourself and give somebody the time to arm themselves. Therefore, a no-knock warrant would be a good application in this particular example. Or danger that evidence will be destroyed or the suspect escaping. So you can do no-knock warrants. And again, we talked about night service. And search warrants are typically between 6 a.m. and 6 p.m. However, it is reasonably necessary to serve the warrant between 10 p.m. and 6 if we get authorization from the judge and we can show good cause for night service. And the judge will determine whether or not this good cause actually exists. So number 3 on the list of 5 that we're going through are protective sweeps. So a protective sweep may be conducted for the safety of the officers immediately after entering the building. And this may expand a search for security of police a little bit, but limited to personal safety only. And they call this a buoy sweep because it's based on a case law where the defendant, of course, was Bowie. So an example would be if we kick in the door and we enter into the building, we're allowed to kind of go through the home quickly and look in rooms to make sure people aren't hiding that could assault us or attack us. But we can't start searching in drawers and doing all that stuff Okay, this is more of a sweep for safety. And then again, there are number 4, the searches must be restricted to the area described in the warrant. So we can only look in those locations that could contain the evidence we're looking for. And I gave you the example about the TVs. You can't look in a jewelry box for a 50-inch screen TV. That doesn't make sense. Now, if it was a bag of cocaine, that would be different. So you can see how that's applicable. And then finally, a return must be completed after the search and sent to the courthouse. And this is filed after the execution with the description of the item seized. So here's that picture that I probably should have put at a different place, but it's okay. And we just talked about the example of the 50-inch big screen TV. So when you look at here, could I search this little bag for a 50-inch big screen TV? Well, no. Or how about this basket with a little blanket? Or these bottles? Or this little box? But could I search maybe in here? So yeah, so the example here talks about officers they're searching for marijuana. So they may seize if officers can identify as marijuana without opening or physically examining. But here they're talking about a search warrant stated that officers may search this garage for an assault rifle and a 55-gallon drum of methamphetamine pills. So if we're using the methamphetamine pills, the 55-gallon drum, well, we could probably search that because that looks like one. But what about the assault rifle? Can we look in this little box right here for an assault rifle? So again, it does limit your search a little bit. So let me add a little bit more on knock notice because that can be kind of confusing. And then we got to jump into the last part, which is the exclusionary rule, so we can be done. So prior to entering a house, like I said, officers have to comply with what's known as knock notice and announce procedures unless, some special situation exists. And this rule applies to all police activity, not just the execution of warrants. However, the Supreme Court did rule in Hudson versus Michigan that failure to comply with knock notice wouldn't always result in the suppression of evidence obtained. But the proper knock notice procedure requires 4 basic things, and this is what I want you to know. That police knock and otherwise announce that they're there. They have to identify their official capacity. They have to announce why they're there. We have a warrant for your arrest, etc. And then they have to wait. Now, the Supreme Court indicated that the crucial question is how long the suspect would take to destroy the evidence, not how long it would take a cooperative person to come to the door. So if no one responds quickly, if you will, officers can resort to forced entry if necessary. So just kind of an example of the knock notice. And then finally, what about this exclusionary rule thing? And what does that mean? Well, Weeks versus United States decided in 1914, and yes, it's an old one, declared that evidence obtained by federal agents in violation of the Fourth Amendment could not be used in federal court. Well, that was great, but at the time then, state court could do that. So a case that kind of came after that, and that's why typically you'll see them together, Mapp versus Ohio, was decided in 1961. And that basically made unconstitutionally obtained evidence inadmissible. Now, and that's the exclusionary rule, if you will. So, although Mapp versus Ohio made unconstitutionally obtained evidence inadmissible, it didn't provide guidelines to help the police determine when the Fourth Amendment was violated. Now, the court issued many decisions in the years following MAP in an effort to clarify the application of the Fourth Amendment. So the Supreme Court's primary rationale for the exclusionary rule is like deterrence. The rule is applied if the court believes police officers will be more careful if they know their errors may mean that they cannot convict the criminal. And the reverse of this has also been seen. If the court believes that the application of the rule would have little deterrent value in a specific situation, then it allows the evidence to be used, even though it might have been obtained in violation of the Fourth Amendment. Wow. So it is a little bit confusing here. But all in all, evidence, the exclusionary rule, evidence seized in illegal searches typically would not be admissible against the parties whose rights were violated. And again, at first was applicable only to federal courts in the Weeks case, and later it expanded to cover all police in federal and state in the MAP versus Ohio case. And the rationale is that it deters that unconstitutional behavior by police, and it also preserves judicial integrity. And here's the MAP versus Ohio case. So police were looking for a bombing suspect and gambling equipment, and they went to Mrs. Mapp's house, and she refused to let them in without a warrant. So the police returned later, and they forced entry, waving a fake warrant in front of her. And guess what? No equipment was found. But you know what? While they were searching, pornography was found, and she was arrested. And at that time and at that place in that state, it was a violation of law. So they arrested her. But the Supreme Court took this case and then ruled that, hey, you know what? Evidence found by both federal and state officials during an illegal search, dude, it's inadmissible. So that's the rationale for the MAP versus Ohio case. So applying the law, why to sue or not to sue? Well, some legal scholars argue that the exclusionary rule should be abolished in favor of civil liability for police when they conduct an illegal search. So would civil liability create more or fewer illegal searches? And what about imposing criminal liability on the police? Should we make it a financial penalty? Well, that probably won't work. And what are some other countries do? And then what finally is this fruit of the poisonous tree thing? Because it sounds really kind of cool, and it actually sounds kind of funny. So let's talk a little bit about it. The Supreme Court's language in MAP, in that case, MAP versus Ohio, indicated that illegally seized evidence is totally inadmissible in court. Now 2 years later, in another case, Wong Sun versus United States, the court went a little bit further and declared that evidence derived from illegally obtained evidence was also admissible. And this is called fruit of the poisonous tree. So think about it. Evidence derived from an illegal search is also admissible. Not just the evidence that you found, but anything that you get as a result of that evidence that you found. So example, a diary discovered in an illegal search with directions to crack houses and drug houses and people. That would be inadmissible because the diary itself was obtained illegally. Does that kind of make sense? And then also, just on top of that, getting a warrant after you do an illegal search won't help you. It won't allow evidence to be admitted. So you can't use that as a way to get around this fruit of the poisonous tree type thing, okay? And here's the Wong Sun case. So sometimes called the Chinese laundry puzzle case, due to all the colorful names in it. Police executed an illegal warrantless search of Blackie Toy's laundry. And Toy implicated Yi, who then implicated his supplier, Wong Sun. And later, Wong Sun voluntarily returned to the police and confessed. And at Yi's trial, Toy's statements were excluded under that fruit of the poisonous tree doctrine. Now, Wong Sun's confession, however, remained admissible as the court created an exception for that. And we're not going to get into the exception of that, but it's called an attenuated taint. And again, I just wanted to show you the case, not totally freak you out again. So, finally, exceptions allowing admissions. The good faith exception to the exclusionary rule. So in 1984, the Supreme Court recognized a good faith exception to the exclusionary rule. And the basis was United States versus Leon and Massachusetts versus Shepard. And here officers must be acting under an objective belief that what they are doing is in fact constitutional. Now, as part of that, they must stay up to date on the law of searches and seizures and confessions, and the facts must be such that a reasonable officer could have made kind of an honest mistake. And if the officer has an ulterior motive, then that exception doesn't apply. However, acting in good faith is really not enough here. The rule applies only in a few distinct situations. It has been applied to actions done under search warrants that appeared to be valid on its face. So officers must be acting under an objective belief that what they are doing is constitutional. The facts must be such that a reasonable officer could have made an honest mistake. And if the officer has an ulterior motive, then the exception doesn't apply. And another thing that kind of comes into play would be what they call inevitable discovery. And this is based on the idea that the police, you know what, they would have found the evidence even if they had not used constitutional procedures. And I'm going to kind of skip through that because we're getting way past our time frame. And a couple of other exceptions would be what they call independent source. And this is where the police relied on some independent, valid source. Or even public safety, where the public faces immediate physical danger if the police don't search. And that would be like looking for a lost gun. And knock and announce, if violated the knock and notice requirement, the subsequent search isn't always invalidated. And then there are some procedural exceptions that are also listed in there, and one would be the harmless error rule, where, you know, this would come into play if the admission didn't alter the trial. And the grand jury, they're not subject to the exclusionary rule. And impeachment, the exclusionary rule should not support perjury. And deportation or sentencing or parole revocation or searches by private parties. So these are some of what they call procedural exceptions. Now, one other thing, sorry, it's going long, but I keep finding things that I want to throw out there to you, would be impermissible methods of obtaining evidence. And we're not talking about necessarily like improper, like search. We're talking more of something that might typically be a violation of due process. And that's kind of where they what we do is we shock the conscience of the court, and it can never, or we can never physically coerce suspects. And it does limit the evidence obtained from the human body without consent. So, like a blood draw, we're not allowed to chase you down, tackle you, and because we think you're drunk, stick a needle in your arm and suck out your blood because, A, it's not medically done properly, but it might also shock the conscience of the court, if you will. And you can read a little bit more about that in your textbook. And then finally, the Tennessee versus Garner case. This is one that was changed as it relates to deadly force. So here, limits on the use of deadly force or a seizure were basically formulated by this case, Tennessee versus Garner. And then here's the case that talked about shocking the conscience of the court. So this is Rochin versus California. Now, without a search warrant or arrest warrant, the police entered Rochin's house and his bedroom. And Rochin swallowed some capsules that the officers thought contained drugs, at which time the officers tried to make him vomit. And then later the police took him to the doctor and basically had his stomach pumped to recover the drugs. And in this case, the evidence was excluded because it violated the 14th Amendment's due process provision, where again, the court called the police action here a shock to the conscience of the court. Okay, so that was long. And again, I went way over, so I apologize, but I think you needed me to make sure we got through all of the information. So quickly, don't forget about the resources in the book. Look at the examples that are in your textbook, especially in this chapter, to add some context again to what we've been talking about. So if that's it, until next time.